What exactly is a DUI? Why are there separate charges on my ticket? Attorney George Creal explains that DUI stands for driving under the influence, and in Georgia, there are 6 different ways you can be charged with a DUI. 2 involve driving under the influence of alcohol. 2 involve driving under the influence of drugs. 1 involves drugs and alcohol in combination, and 1 involves inhalants. The 2 types of DUI involving alcohol are the most common types of DUI we encounter in Georgia. There are 2 types of alcohol-related DUI charges, per se and less safe. A per se DUI is when the blood alcohol level, breath alcohol level, or urine alcohol level of the accused is greater than the legal limit of 0.08 grams within 3 hours of driving or being in actual physical control of a moving vehicle from alcohol consumed prior to or while driving. A Georgia DUI can also be per se drugs if an illegal drug like cocaine, meth, or heroin, or their metabolites excluding marijuana, is detected in any amount in the blood or urine of the accused. The alternative to a per se DUI is known as a less safe DUI. A less safe DUI is when a driver is arrested for DUI but no breath or blood result is available, or the available test is suppressed or excluded from evidence by a judge. Less safe means that the driver is less safe to drive as a result of consuming alcohol or drugs before or while driving than if the person had not consumed or ingested any drugs or alcohol at all. Less safe means less efficient, less capable, and less able. However, proving the mere presence of alcohol, marijuana, or illegal drugs without some additional evidence of impairment is insufficient. A less safe DUI can be proven in 3 ways: direct evidence of erratic driving, like an accident or weaving due to alcohol or drugs. Circumstantial evidence of less safe driving inferred from poor performance on standardized field sobriety evaluations, and circumstantial evidence of a driver's appearance and demeanor, such as odor of alcohol, unsteadiness and staggering, stumbling, glassy eyes, or slurred speech. Under current law, unlike other illegal drugs, a Georgia marijuana DUI can only be prosecuted if the state can prove beyond a reasonable doubt that the driver was a less safe driver or incapable of driving safely because of marijuana use. Mere presence is not enough to convict on a marijuana DUI. Additionally, you can also receive a DUI for driving under the influence of prescription medications lawfully prescribed by your doctor and taken as instructed if it can be proven in a court beyond a reasonable doubt that the prescription drugs rendered a driver incapable of driving safely. Finally, an alcohol and drug in combination DUI can only be prosecuted if the driver can be proven to be less safe. Less safe DUIs are generally harder to prosecute for the state. Marijuana and prescription drug DUIs are especially difficult for the prosecutors to prove in court. Take the safe road by hiring attorney George Creal and his team, who bring over 50 years of courtroom experience to counsel's table, providing your case with the individualized time and attention to detail required for success.